So friends, now the next topic is advance rulings. And this is section 28E up to section 28M. So you can open the material. Initially, I'll go a little slow so that you can open that. Hmm? And some of the questions may be there in the exam from this topic. So what we are going to see in this is what is the meaning of advance ruling, why somebody should apply for advance ruling, who can apply for advance ruling, on what subjects advance rulings can be obtained, what is the binding effect or validity. All these are the questions which we are going to understand in this lecture. So first of all, what is the meaning of advance ruling? If you look in the definition section 28E, this says advance rulings means a written decision. I have a different opinion. This is not a decision. This is again an opinion expressed which is binding. Anyway, written decision on any of the questions referred to in section 28H. Let us see one by one what it says. So advance ruling means decision on any question under section 28H. Now you can understand that advance ruling can be obtained only on the questions which are referred under section 28H. You cannot go for advance ruling on anything, only specific questions. And these questions are, before I go on 28H, let me explain you what are these questions. These are the subject matters directly affecting tax liability. So those are immediately or direct, those are having direct connection with the taxability or the amount of the tax. What is the classification, what is the valuation for those goods, what factors will be considered for valuation, what will not be considered for valuation, whether exemption notification is applicable or some duty is applicable or not, or the credit subject will be there or not. So all those things are directly related to tax matters. So when we say decision on any question under section 28H, instead of that you can say which are directly going to affect the tax liability. And this tax liability is in relation to import or export of goods. But before import export takes place, because once the import export has taken place, taxable event has already happened, then nothing can be done. So this is decision on any question which is directly affecting the tax liability, but this is before taxable event takes place. So this before is very important, because once the taxable event has taken place, then this advance ruling authority cannot do anything. Then thereafter it is purely it is adjudication work and appellate work. In that case, advance ruling is not possible. So this is before the taxable event takes place. Now what is taxable event for the purpose of customs? For the purpose of a taxable event is import, export, right? And that too only goods Customs Act doesn't deal with services. Right. So now you understand this. There's a decision on any question which is directly affecting the tax liability relating to import and export of goods. But before import export takes place. Now read the definition. So clause B says section 28E advance ruling means a written decision on any question referred to in section 28H raised by applicant in his application in respect of any goods prior to importation or exportation. Now, once you have understood this, then reading and understanding the definition becomes very easy. Right. So before the taxable event takes place, there may be a certain question, there may be a certain doubt which is directly affecting the tax liability, because if the classification changes, rate of duty may change. Exemption notification, applicability, non-applicability, the total amount of tax can change. Some specific tax applicable, not applicable, that can change a lot. Place of origin, country of origin can change the tax structure. Those questions may be there. So how those questions can be answered once you have already imported or exported the goods? In that case, there will be adjudication and then there is appeal. But how to ensure that those litigations are not there? So when that advance ruling is obtained before importation exportation, this advance ruling is having binding effect on the authority. He cannot go against this. So the applicant is sure that this is going to be the tax liability, and the adjudicating authority is sure that this is the final decision in the given situation. So reason for further litigation can be avoided by going through the advance ruling process. But advance ruling is only and only on questions which are directly affecting the tax liability before import and export of the goods. Doesn't apply to services, doesn't apply after the import export has taken place. Okay, understand that. Now, who can apply? Applicant. So the definition of applicant is completely changed. Now this says applicant means holding a valid importer exporter code number under section 7 of the Foreign Trade Development Regulation Act. So that you have already studied, or maybe you can read it later on under the foreign trade policy, that every person who is willing to import export goods is required to have the importer exporter code number. Without that, this is not allowed. So first of all, every person who is having a valid importer exporter code, or number two says exporting any goods to India, means this person under clause B is not exporter from India, he is exporter from overseas sending goods to India. He can also apply for advance ruling or with a justifiable cause to the satisfaction of authority. Means we are not restrictive whether individual or HUF or partnership or company or body corporate or LLP. We are not saying anything. We are saying any person who is having importer exporter code. Number two, any person who is sending the goods from outside India to India. Number three, any person who can satisfy the authority for the purpose. So literally every person who is in the activity of import or export or proposed to be engaged in the activity of import and export can make an application for advance ruling only on the questions which are covered under section 28H. Now in the explanation, the first explanation is absolutely not relevant because that talks about the joint venture, and joint venture was earlier defined as an applicant. Now this word you don't find here, simply put across. You don't need that. Okay. Now coming to the next section 28EA, this is custom authority for advance ruling. Custom authority for advance ruling. So here this says the board, the central board can appoint a person of the rank of the principal commissioner or commissioner as custom authority for advance ruling. Right, custom authority. Okay, and before this appointment, the authority for advance ruling constituted under the Income Tax Act, that was the authority for advance ruling. So section 28F is talking about that when this authority is custom authority is appointed, then thereafter all further cases will be with the custom authority for advance ruling, and before that whatever is lying with the appellate authority constituted under the Income Tax Act, those will get transferred to this. So those sections are no more relevant for you. 28G is already omitted, so we are not talking about. 28H, this is very important section, and actually if I tell you correctly, this is the crux of the entire chapter. Application for advance ruling. Which are the subject matters? Section 28H. application. When the application should be made? Before the taxable event takes place. On what subjects which are defined here under subsection 2, right? How it is to be made? So little bit things are given, that application is to be made in the quarter applicant, and it can be withdrawn within a period of 30 days, and the application or the applicant can be represented by any person who is so authorized. So this I can divide that in two parts only for your understanding and making the things easier. Number one, here we can divide subject matters, subjects, and here we can say others. So in others, we'll write little later, subjects are covered under subsection 2. So subsection 2 says classification of goods under the tariff, applicability of notification issued under section 25, that is exemption notification, the principle to be adopted for the purpose of determination of value, that is valuation, applicability of the notifications in respect of tax and duties under the custom tariff act. So that is protective duty, safeguard duty, duty against subsidy, anti-dumping duty, we are talking about those duties. Then determination of the origin of the goods, and that is with respect to the preferential rate of duty, and any other matter central government may notify. So what are the subject matters? Here we can say, number one, classification, then valuation. So in valuation, we cannot request the authority to determine the value. We can ask whether this is applicable or not, whether a specific question, specific things will be covered in the valuation or not. Then exemption notification, exemption under section 25. Then specific duty under custom tariff act. Then in addition to that, what are the topic I just missed out? Yeah, yeah, country of origin, and any other notified by central government. Now you see, I told you that every subject matter is directly pertaining to the amount of duty. Classification, a rate of duty can change. Valuation, if the value changes, amount of duty can change. Exemption, whether duty is there or not. Specific applicability, that is again the duty, and any other that should also be related to duty only. Okay. Then, other than that, apply in 4 copies. And once application is made, application can be withdrawn within 30 days. Because once it is withdrawn, then there is no concept of surrender of the advance ruling. Only thing possible, go for appeal. Right? No question of surrender. Therefore, first 30 days, literally, there is not going to be any action on the application. So, withdrawal within 30 days. This is withdrawal. This is not about the decision. Applicant wants to withdraw the application for advance ruling, he can, and the time limit given for that is 30 days. 30 days starting from the date of submission of the application. So that can be withdrawn within a period of 30 days. Okay. And then it further says representation by any authorized person. Representation by any authorized person. So who is authorized under the Customs Act, he can represent the applicant. Okay, so this is about the application under section 28H. These are the subject matters, these are other things. Application in 4 copies, want to withdraw within 30 days, and representation of the applicant by any person who is so authorized. And these are the subject matters on which application can be made. Now, once application is made, what will happen? That is under section 28I, and that says on receipt of application, the authority shall cause a copy thereof to be forwarded to the principal commissioner or the commissioner if necessary, and call upon him to furnish the relevant records. Because ultimately you are asking for a decision on a question pertaining to the amount of duty or relating to the dutiability of the product itself or the rate of duty. In that case, the authority for advance ruling is going to call for records from the principal commissioner or commissioner, and as soon as those records are purposes served, those should be returned. And the authority may, after examining the application records called for, either allow or reject the application. So subsection 2, that is more important, when application shall be rejected. Shall be rejected. We are not giving the option. Rejection. Section 28I, application shall be rejected if, read the wordings carefully. What I have written, shall be rejected, means authority for advance ruling also does not have any choice whether advance ruling can be given or not. First situation, the subject matter is already pending before the adjudicating authority. It means the taxable event has already taken place. So where the taxable event has already taken place, advance ruling authority cannot do anything. You know the applicant, the definition of advance ruling. We said before the taxable event takes place. So first situation where application should be rejected for advance ruling, that is number 1, subject matter pending before adjudicating or appellate authority. So the same subject, same applicant that is pending before the adjudicating authority or the appellate authority. It means the taxable event has already taken place. That's why the adjudicating authority has taken a decision or it has passed an order and the matter has gone to appeal. While advance ruling is before the taxable event takes place. So this is one situation where application has to be rejected by the authority. Number B, the same as in the matter is already decided by the appellate tribunal or by the court. Same subject has already been decided by the court or tribunal earlier. So this point number B is showing that the position of authority for advance ruling cannot be considered as superior to appellate tribunal or the court. So where similar subject matter has already been decided by the tribunal, that is appellate tribunal or by the court, that subject matter will not be touched upon by an authority for advance ruling. Because if this is the situation and the authority gives an advance ruling, that will be contradicting this authority, the court. That is not possible. So these are two situations in which application shall be rejected. Any other situation, discretion. But in these two situations, no discretion, it cannot be rejected. Okay. Now that is one part. Now it further says, provided that where the application is rejected, reason for the rejection shall be given in the order. Right. So whether these reasons or some other reason, Reason for rejection should be given. Why? Because if the person wants to go for appeal against the rejection, if this is the ground, question of appeal is not there. If any other ground, he can certainly file an appeal. That's why whenever the application is rejected, there has to be a written order, and the written order should specify the reason for rejection. Why written order? Because appeal is there. And if these are the subject matters, appeal will not be there. Then further, coming to subsection 6, they say the authority shall pronounce, underline the word shall pronounce, 28I subsection 6. I have written in red knowingly because this MCQ can be framed on this. Advance ruling shall be announced within 3 months since application is received. So what can be there in the MCQ? This is 45 days or 60 days or 90 days or 3 months. Which is correct? Right? You know the answer that this is already correct. So MCQ can be framed on anything. You should know the law in detail and understand the minor and finer points. And that is what I've been doing everything on the board, so that you have every minor and finer points noted in your notebook. So this will help you to revise, right? So only practicing MCQs is not going to not going to serve any purpose for you. Understanding the law is going to help you in every way. Okay. Anyway, so this advance ruling shall be announced within 3 months since application is received. Okay. Now, once this is announced, we move to the next section, and that is section 28J, and that is talking about the applicability of advance ruling. Rather, if I change the wordings, I can say binding effect of the advance ruling. So, section 28J, this is binding effect of advance ruling. Applicant adjudicating authority and subject matter on which advance ruling has been given, right? So these three things combined together, there is a binding effect. So the application has been made for a specific question, so that comes here, subject matter, applicant, specific subject, and authority. The authority does not have a choice of changing the decision. Any other person, even if situation is exactly same like the applicant, no binding effect. So here we have the binding effect, any other person. No binding effect. So your question can be that as long as binding effect is there, the adjudicating authority is also bound by the advance ruling. Correct. What will happen in case of another person? I say no binding. It means the adjudicating authority can change the opinion for another person. Yes, it can. But practically, adjudicating authority will not change in the similar circumstances because he will have the support of this advance ruling. Outsider cannot claim the benefit of advance ruling, but 99.99% the decision will remain same there. Don't write it anywhere. It is only for your understanding. And then section 28L, rather K. This is advance ruling to be void in certain cases. When? This simply says where advance ruling have been obtained by fraud. So either advance ruling authority gets to know by itself, or it is brought to the knowledge of advance ruling authority that advance ruling have been obtained by fraud or misrepresentation or suppression of fact. In that case, it can withdraw the advance ruling. So under section 28K, I will give you a different perspective. Advance ruling becoming ineffective and advance ruling declared void. There is a huge difference. Now, when the advance ruling are given, that is based on the law as on that day. What will happen if the tomorrow law itself gets amended? Then if the law gets amended, the advance ruling will no more be further effective. Whatever has been done on the basis of advance ruling, that will continue to be valid. So this is before amendment and after amendment. Before amendment and after amendment. So before amendment, this is binding, and then not binding. So actually, this is not the part of section 28K. 28K is here where advance rulings are obtained by fraud or misrepresentation. In this situation, advance ruling may be declared void since given. Now see what is the difference. Here it is we said this is happening because of amendment in law. So before amendment those are binding, after amendment those are not binding. In this case what is happening, advance ruling declared void since given, it means those are not having any effect since beginning. And in further you can say as if advance rulings were never given. As if advance rulings were never given. And not only that, those will be void from the beginning. It further proviso has been added, and the proviso says that if any notice is issued under section 28, then the time limit of 2 years or 5 years which is given for issue of the show cause notice, then that will get extended for the time when advance ruling were applicable. So that period of advance ruling will not be counted for that period. So something very dangerous. So where advance rulings are obtained by fraud, a misrepresentation or suppression of fact, and it is brought to the knowledge of authority or it is noticed by the authority, then after giving an opportunity of being heard, that those can be withdrawn. And if withdrawn, then it will be treated as if those were never given. Then next comes 28KA, that is appeal. The any person who is aggrieved by an order passed by appellate authority or by the order passed by the authority for advance ruling, it can file an appeal before the authority for advance rule, appellate authority for advance ruling within 60 days, and a good cause being shown, it can be extended within further period of 30 days. So 28KA, this is appeal. Order by authority for advance ruling. So this is custom authority certainly, right? Appeal by aggrieved party. Time 60 days. So 60 days certainly from the date of the order of the authority. And extension. Extension is a discretion of the appellate authority, and this is 30 days. So, on a reasonable cause being shown, the appellate authority may accept an appeal even after expiry of the 60 days, but within next 30 days. Right? So, this is final. And 28 L and M, those I'm leaving for your own reading because there is nothing much to discuss in that. And the time limit is applicable, so that is okay. So, this is all about advance ruling. So let me brief you once again what we talked about in advance ruling. So advance ruling, these are the decision of the authority for custom authority for advance ruling on any question regarding the amount of duty or the duty ability of the product or the rate of duty, etc. before import or export of the goods take place. And for that purpose, any person holding a valid importer exporter code number or any exporter overseas or any person who can satisfy the authority of the eligibility, he can apply for advance ruling. But application should be made before the taxable event takes place. Application can be made on specified subjects, and those are regarding classification, valuation, exemption, any specific duty, country of origin, plus any other subject as may be specified by the central government. Now, once application is made, it can be withdrawn within 30 days, thereafter no right. And application or rather advance ruling should be rejected in two situations. Number one, where the subject matter for which application has been made is already pending before the adjudicating authority or the appellate authority, or the similar subject has already been decided by the court or by the tribunal earlier. Otherwise, this should be advance ruling should be announced within a period of 3 months from the date of receiving the application, and the advance ruling are binding on the adjudicating authority on the applicant on the given subject, and the binding effect is not there for any person other than the applicant. And where it is shown to the authority that the advance ruling have been obtained by fraud or misrepresentation, then those can be declared void from the day one, and in that situation it will be treated as if advance rulings were never given. And any person agreed by the order of the authority for advance ruling, he may prefer an appeal before the appellate authority within 60 days, and on reasonable cause being shown, an extension of 30 days can be granted. So friend, this is about the advance ruling. We will meet in the next video. Till then, keep on studying. Thank you very much.